Welcome back to the No Say Project. I'm your host, Mark Stevens, author of Government Indicted, and you can get that all right here at markstevens.net. It is a live edition of the No Say Project here on LRN.FM, the Liberty Radio Network, live, of course, from the fortified compound in Mesa, Arizona, because those of us who have the audacity to question the orthodoxy, we don't live in homes, we don't live in a house, we live in a compound. Even if there's only one structure on the property, you still live in a compound. Ridiculous. But, well, glad to be back here with you. And we got Scar in Tucson, who's going to be also doing some role-playing. So appreciate all the help that everyone is able to do in the No Stay Project Skype chat. Big resource. Definitely do the role-playing. Do not take the script and just read it in court. They will single you out and falsely accuse you of being a sovereign citizen or a freeman on the land, because that's one of their red flags, that you're just reading from a script that you don't actually understand. So make sure you bring the script and you use it, but don't rely on just the script. You do the role-playing. You go to the city council meetings, and then you can confront them right there in person. So not only is it great that you're doing that, you're putting them on the spot, but you're learning how to defend against the crap that these people are going to be throwing your way. So what I mentioned earlier was this, and I don't get this very often, that they do respond. And so when we do get a prosecutor's response, I tend to post them because they're just they're just ridiculous. I mean, a level. Oy vey. So I posted part of what Rudy Ogden here did a few days ago, and this is where, legal citations are not evidence. Uses legal citations as evidence. So I posted the document there. So if you go into the video, you can see that. So here my gosh, again, I just got this today, and it is just, oh man. So we've got this guy, Andrew M. Nelson. I guess he's actually a partner. So this is a man who's very comfortable life. I mean, you're not a partner in a law firm that's prosecuting cases there. You're making some bucks. This guy. So what he did, this is what's unusual too. This is not a formal pleading. You can see this is a letter. This is an informal response. And he says to Peter Close, who's, I guess, a judge of this Wisconsin municipal court, it's his response to the motion to dismiss. And so I asked him in an email, which I don't think I'm going to get a response to, but I will post that if I get a response, because I'm sure it'll be as good as this. This is just, wow. Accept this letter brief as a response to the motion to dismiss and or strike the citations issued. Okay, so I blow this up a little more, but it's not a very good picture, so it just pixelates too much. So hopefully you should still be able to read this in the video. Defendant claims a number of legal excuses and defenses as to why the law either doesn't apply to him or that the very issuance of a traffic ticket in Wisconsin is unlawful without jumping through a number of cherry-picked dicta. Okay, so now legal principles of standing and jurisdiction are merely dicta. Okay. Arising out of Wisconsin and traveling to such far-flung legal fictions or states as the rest of us call them. Yeah, they're legal fictions, Andrew, such as California, Florida, Maryland, and even the tropical beaches of Hawaii. You see the sarcasm this guy starts off with? The tropical beaches of Hawaii? What the hell does that? Okay, so the reason why we cite the corpus delicti from so many is to show that this is not a limit, something that's limited just to the tropical beaches of Hawaii. This is something that is, it's a common thing. It's all over every so-called state, and even in Canada and England and Australia, they have the same thing. It's all from the same garbage. Fortunately, the court is not a performing bear required to dance to every tune played by a particular defendant, and is not required to respond to such legal gibberish. Gibberish? It was in like a 12th grade English. it's obviously you were able to read it because it wasn't gibberish, but that's something these attorneys can't read. Yeah, it's not that they disagree with your argument. It's not that they disagree with your statement. It's gibberish, just to dare to challenge. Gibberish. Well, 12th grade English, it's not gibberish. You can understand it. He says, regardless, this court is well founded on state constitutional and case law in proceeding on the facts of each and every citation issued by the... Well, no, if not unless there's jurisdiction. There has to be jurisdiction. So he states that he has failed to allege a violation of right. Therefore, there is no standing for the village to bring the matter before the municipal court. To support this bizarre theory, how is it bizarre? What? I'm just, if you go to the standing cross-reference, it's a bizarre that has to be an injury pled. Right? Governments are instituted among men deriving their just powers from the consent of the governed and are established to protect and maintain individual rights. Where is that bizarre? It's bizarre if you think that that's real, that's true, that that's why the government was established, or what we call government. But other than that, no, I don't see that. But if we go down here, as far as the issue of standing and a cause of action, even when you go down to Wisconsin, it seems to be their black letter law here. Let's see, Wisconsin. Wisconsin employs a two-step standing analysis. The analysis requires the court to determine, one, whether the plaintiff has suffered, that may be a typo there, has suffered a threatened or actual injury. How in the hell? Law of standing is to be construed liberally where an actual injury is demonstrated. How is that bizarre? How does that... What? I don't get how he's saying that that's bizarre. He's never heard that before? Then this is where he says I'm cherry picking because to support the bizarre theory, he cites Tyler v. Judges of the Court of Registration, quoting, "The duty of this court, as of every judicial tribunal, is limited to determining rights of persons or of property which are actually controverted." They're talking in a general sense about every judicial tribunal. How the hell is... This is just... Again, this is just absolute... I hope to maybe be able to get this guy on the phone because I'd like him to explain what is bizarre about saying that you need to have an injury pled in order for there to be a cause of action and standing. It says it right there. Wisconsin employs a two-step standing analysis. There has to be a threatened or actual injury. What? So the principle is sound. What is bizarre is why he would actually not pretend to not understand it. So the reasoning he's giving here has nothing to do. He doesn't even address that this is about every judicial tribunal determining the rights before it. This is a prime example of the defendant's attempt to chase Dick down a rabbit hole and take us all with him. What the hell are you talking about, Andrew? This particular quote was cherry-picked because his argument is that every judicial tribunal is limited to determining rights. Yeah. And since the citation doesn't claim a violation of a right, is therefore not met the threshold. Yes. That is according to their own code. We'll be back with more of this garbage in just a moment. Don't go away. Yes, welcome back to the No State Project. I'm your host, Mark Stevens, author of Government Indicted. Let's get right back into this. I actually found a picture of Andrew Nelson. This is a guy who is arguing that having to have an injury pled is a bizarre theory. Okay, and where is he saying that? To support this bizarre theory. Well, bizarre theory, yeah, but it's actually black letter law. It says, again, for those just tuning in, the analysis requires the court to determine, one, whether the plaintiff has suffered a threatened or actual injury. So it's only bizarre to Mr. Andrew Nelson because he doesn't like it getting in the way of his gravy train and getting in the way of him collecting more money from peaceful people in Wisconsin. That's why it's bizarre. Like, how I have a complaint. How that's so bizarre. So, wow. Yeah. Okay. So let's get more into this. This is a prime example of the defendant's attempts to chase dicta down a rabbit hole. Wow, a rabbit hole. Again, that's from their own Supreme Court.
You don't like rabbit holes.
No, I don't.
You like a different kind.
Hey, now. So Andrew thinks that this is bizarre and that we're going down a rabbit hole. Oh, how about we're just reading your Supreme Court and what the and that's the thing. If one of us were to sue him, this guy Andrew, he would be the first one to challenge jurisdiction on and show that there's not a valid cause of action because there's no legal injury and damage. But it's bizarre when we do it. Okay, the bizarro world is all opposite. That's right. Maybe he's a big Superman fan, and that's what's going on over here. Defendant's argument, however, completely disregards the purpose and the content behind the quoted learned Justice Brown. Clearly, the case was not about whether or not... No, I'm not ignoring that. I'm talking about the legal principle that the court is just... All courts are there to determining rights. Had nothing to do with creating case law regarding the limitations imposed on judicial tribunals. Yes, it did. They had to have a case of controversy. The case of controversy clauses that most constitutions have. In this case, we are not arguing over rights, but privileges. Excuse me. Your own code there, tough guy. Yeah, it has to be suffered a threatened or actual injury. So, yeah, you can call it a privilege, but that you still have to have a valid case of controversy before you. So, okay, I hit the wrong thing there. Specifically, as this argument pertains to the Motor Vehicle Code, the weight of authority is to the effect that the driving an automobile upon public highways is a privilege, not a property right, and is subject to reasonable regulation. But what you're not understanding, Andrew, is your argument is that if he's physically in Wisconsin, your laws apply. And you're not, he never addresses that. He just goes into legal arguments. The state's police power has been defined as the inherent power of the government to promote the general welfare, since the state was exercising its proper police power. Yeah, but is there evidence that your laws apply because he's physically in Wisconsin? No, and he never even attempts to address that, as we'll go through here. Here he's going through, talking about the corpus delicti. He says, first, this is not a criminal offense. Well, if and the motion to dismiss is written for both. So if it's not criminal, just disregard that. If it's not civil, then disregard that part. But since it is civil, to have standing, there has to be a threatened or actual injury. But our hero, Andrew Nelson, seems to ignore that and just wants to use insults. So we'll get back to that. In part of the ramblings presented by the defendant under this heading, he appears to make the argument that there is a requirement that an injury or loss has actually occurred and that the criminal act was the proximate cause of the injury or loss, and that those phrases and terms must be pled on the face of the citation itself. It is well-settled law as described that the state may enact it, but it's also well-settled law about the corpus delicti. While the corpus delicti must be proved beyond all reasonable doubt, it may be established by circumstantial as well as direct evidence. It's not even there. It is not even there. And yet he wants to turn around and argue he doesn't have to. Well, the laws say otherwise. But again, this is just one of the many ramblings that we had in the motion. Ramblings from the Supreme Court. In fact, there are plenty of criminal and civil codes that could be proven without having to prove intent on behalf of the defendant. But you have to prove the injury. This argument makes no sense, and for the reasons already argued, should be denied. No one argued intent. It's not even in there. Intent is not mentioned in the motion. A lack of evidence is in there. All right. Next to the defendant circles back. What is this? What? Dude, I mean, what are you, 15? What? It circles back. What the? Because there is no standing, because no legal injury has been pled, because no violation of legal right was alleged in the citation. For the reasons, for the reason right here and in the motion, standing, the plaintiff has suffered a threatened or actual injury. It's not there. So no, you haven't defeated that. Next, the defendant claims that the complaint or citation is unfit for adjudication, relying on the Supreme Court decision in Poe v. Ullman. This is another prime example of the defendant choosing a term or phrase issued in this case by Justice Frankfurter and attempting to twist it and its message and massage its message. The term adversary relied on by the defendant is not as he claims it to be. An adversary proceeding in legal terms references whether or not there is an actual claim, or controversy before the court to decide, thus making adversarial. In Poe, the court does say there has to be an actual antagonistic assertion of rights for it to be adversary. Not that just because that's what makes it an adversarial controversy and something that's right for the courts. Just two people disagreeing, that may be a controversy, but it's not an adversarial type of controversy unless there's an actual antagonistic assertion of rights. That's what they said in Poe v. Ullman. That is the key. That's what makes it adversarial. He ignores that. It doesn't matter if they were just seeking a declaratory judgment. That's irrelevant. What he's doing is giving a principle of what makes something an adversarial proceeding, and that is the actual antagonistic assertion of rights. That's it. That's what he said. That's what they wrote. And that makes sense because the courts are only there to adjudicate justiciable cases of controversies. Then he says the defendant next argues that there is no evidence that he was found within the state of Wisconsin, and he is not talking about the geographic boundary of the state. He literally wants the court to throw these citations out because there cannot possibly be any evidence proffered to prove he is within the political entity known as the state of Wisconsin, as though Wisconsin is akin to the whale that swallowed Jonah and belched him up 3 days later on the shores of Nineveh. The defendant is clearly mistaken evidence showing him to be subject to the laws of the state of Wisconsin, or in this case, the village of Roberts, Wisconsin, with personal jurisdiction. No, we're talking jurisdiction in total. There's what's called territorial jurisdiction. And he even says territorial. That's territorial jurisdiction if you're within a certain territory, the physical location. He never once, our hero here, and I've asked him this on an email directly. We'll see if we get a response. I don't think I'm going to get a response to that. Can we get that? Oh, whoa, what happened there? I don't think we won't get that, but I've asked him directly, where is your evidence to prove that just because someone is in the territory known as Wisconsin or physically in Wisconsin, that your Constitution and laws actually apply to them? And we don't. So, but you see here, he restates his argument. All he does is restate it. He doesn't produce a single shred of evidence, but what he does is put up basically an insult. As though Wisconsin is akin to the whale. No, we're talking about you thinking that a DBA called the state of Wisconsin, someone can actually be within a DBA or a political body, which is why we put in the motion there, Andrew. I put in the motion that the state of Wisconsin is political because it didn't exist before. You know, it hasn't always existed. I forget the year, like 1850. But this guy thinks that somebody physically in Wisconsin is within the state of Wisconsin. He's the one that is making this argument that Wisconsin is somehow like the whale that swallowed Jonah. Just ridiculous. Look, we're going to be back here in a few minutes. We'll finish up. But again, this is the attorney Andrew Nelson that's doing this. We'll be back in just a moment, so don't go away. Let's welcome back to the No State Project. We're live from the Fortified Compound in Mesa, Arizona. The website markstevens.net. And we'll get right back into talking about this guy. He's an attorney, Andrew Nelson. He's an attorney with some law firm, Nelson and Lindquist, up there in Wisconsin. And what he's doing here, it's funny, we just point out the difference between the geographic and the political, and he makes this ridiculous argument that he literally wants the court to throw these citations out because there cannot possibly be any evidence proffered to prove he is within the political entity known as the state of Wisconsin, as though Wisconsin is akin to the whale that swallowed Jonah and belched him up 3 days later. What the? This is the guy who is clearly conflating the ground with the state. And then talk about and then he actually starts talking about, and I've mentioned this before, everybody, that if you start to actually question them about the state and the physical location or whatnot, and you start using lay terms, they will talk about the territorial jurisdiction of the court or the police or whatever. And the territorial jurisdiction, which includes personam jurisdiction, it's all related. It's all the same. It's all based on the same damn argument you're making, Andrew. If you're physically in Wisconsin, your laws apply, and that there's jurisdiction, territorial, and personam. That's your argument. Making silly statements about a whale is only pointing out how little or no evidence you have and how weak your arguments are. Because you'll notice here, does he have one? Is there anything in here? Is there anything in here that you can see that would show evidence proving the laws apply just because someone's physically in Wisconsin? Anyone see that there? I don't see a single thing here. I see a stupid argument. Let's get to this. Finally, the defendant throws all previously made arguments into one glorious argument to close his motion, alleging that I thought it was gibberish. Hey, Andrew, I thought it was gibberish. You seem to understand quite a bit of it. Maybe, maybe a little hyperbole there with the gibberish. Throws all previously made arguments into one glorious argument to close his motion, alleging that the court cannot simply enlarge its jurisdiction to allow for the exercise of police authority by the village of Roberts. For the reasons stated above, the state and thus the village of Roberts, through exercise of its constitutionally and statutorily allowed police powers, may enforce its laws by issuing citations and having the matter and the defendant brought before this honorable court for just and swift adjudication on the merits of the case. I had to highlight that. It's like, what? Really? Just and swift? Just and swift. Yeah, I think just and swift adjudication. You see, that was supposed to be one of the checks and balances that we were mentioning. I was getting to in the motion to dismiss, that regardless of what laws are passed by one branch, the legislature, if they overstep their bounds, they could not enlarge the limitations of the court. Not when you have something called a case and controversy clause. The courts are limited to justiciable cases or controversies. They're not able to take political questions, only judicial questions. So if they pass a law that exceeds their constitutionally given limits, then according to their own laws, that's, it's unconstitutional and it's not a law. So you can't expand the jurisdiction of the court by passing a law to do what they're not allowed to do. I mean, so if there was to be just and swift adjudication on the merits of this, you would still have to prove jurisdiction first, Andrew, and you didn't do that. You can use whatever stupid references to the Bible you want. You can conflate things all day long. But bottom line, through 3 pages of your rambling, you have not produced a single fact that would prove that your laws apply just because someone is physically in Wisconsin. None of this does. This is in an HD video. People, you'll be able to read the text of this. I will make the each one available, so if you can't read it in the video, then you will have your own copies. But if someone disagrees, if you think there's anything in these 3 pages that even remotely resembles evidence proving that the laws apply to someone because they're physically in Wisconsin, then please feel free to call the show. Respond to the article. You can email me. You can call. It's 218-632-9399. And let me know. Because this is what this man wants. What Andrew Nelson wants is a complete pass, like all these other prosecutors get on the issue of jurisdiction. So what he has to do is he has to make the guy who filed this look stupid, which is a form of I don't have any actual evidence. So what I have to do is I have to make fun of the person. So that's exactly what Andrew Nelson did. He just poked fun at Adam. But you can see clearly in this, there's no merit whatsoever. Just calling something bizarre doesn't make it wrong. And that's exactly what he's trying to accomplish. He wants the judge to think that this is bizarre. The judge probably agrees with him. It's bizarre. The idea that you would even challenge the application of the Constitution is so far beyond what they're used to, so far beyond what they are willing to accept as far as a legal challenge. So the only thing they can do is use hyperbole. All they can do is make fun of it. This is what you can expect. But this is exactly why prosecutors tend not to respond, because the responses are so stupid. They are so lacking in merit. I'm not going to say that this is gibberish, because it's not. It's in proper English. You can read it. I can understand it. It just doesn't have any merit. It does not address the motion at all. So if you are being attacked by some of these people, if you're being attacked by people like Andrew, know that no matter how many pages they go on for, no matter how many comments they make about the Bible, no matter how many things they say here about, one glorious argument to close his motion, they will never actually address directly and provide what we claim in the motion is missing, and that is the evidence proving that their laws have any application to us because we're physically in Wisconsin. And they will never be able to show the legal injury. All they can do, what he does here is just argue about a privilege. He just argues about a privilege. And it doesn't address the issue. It doesn't address the issue. So just know, and there are others like this on markstevens.net, just know that these guys, if they had evidence, they just give it to you. They would just provide it to you. They wouldn't go on for 3 pages. They don't need to go on for 3 pages. All they would do is cite where in the record the evidence was already presented. If the evidence that we said wasn't there had been presented, Andrew would not have needed 3 pages to explain it. All he would have done was cite where on the ticket the evidence was. But it's not there. It's not. And it can't be. And it's no different than when we go here with Rudy Ogden. This lying, this liar, this criminal from New Hampshire. Legal citations are not evidence, and then he turns right around and uses a legal citation as evidence. No different than this guy. And that's all they have. Because these people actually believe, or act as if they believe, that their rules that they call law magically and irrefutably apply to everyone. Everyone. And yet he has the gall to say that what we're presenting is bizarre. Now imagine we turned around and said, I've got this written instrument from 200 years ago, and it says that everybody in this area has got to give me money. And if they don't give me that money, then I have lawful authority to attack them and take their property. Now that's bizarre. When you strip out all that political garbage from these guys, and they don't have that, and all you have are men and women forcing us to pay them, yeah, they lose all their. That's what strips their presumption of legitimacy. Hey, we're completely out of time. Glad to be with you here on the No State Project on LRN.FM. Until next time, salud.